Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled UN Permanent Court of Arbitration or PCA ruling on sojournacy. The sojournacy arbitration. The Republic of the Philippines v. the People's Republic of China. The tribunal renders its award. An unanimous award has been issued today by the tribunal constituted under Annex 7 to the United Nations Conventions on the Law of the Sea. In the arbitration instituted by the Republic of the Philippines against the People's Republic of China. This arbitration concerned the role of historic right and the source of maritime entitlement in the sojournacy, the status of certain maritime features and the maritime entitlement they are capable of generating, and the lawfulness of certain action by China that were alleged by the Philippines to violate the convention. In light of limitation on compulsory dispute settlement under the convention, the tribunal has emphasized that it does not rule on any questions of sovereignty over land territory and does not delimit any boundary between the parties. China has repeatedly stated that it will neither accept nor participate in the arbitration unilaterally initiated. The absence of a party or failure of a party to defend its case shall not constitute a part of the proceedings. Annex 7 also provides that in the event that a party does not participate in the proceeding, a tribunal must satisfy itself not only that it has jurisdiction over the dispute, but also that the claim is well-founded in fact and law. Accordingly, throughout this proceeding, the tribunal has taken steps to take the accuracy of the Philippines' claims, including by requesting further written submission from the Philippines, by questioning the Philippines both prior to and during two hearings, by appointing independent experts to report to the tribunal on technical matters, and by obtaining historical evidence concerning features of the sojournacy and providing it to the parties for comment. China has also made clear through the publication of a position paper in December 2014 and another official statement that in its view the tribunal lacks jurisdiction in this matter. Article 288 of the conventions provide that in the event of a dispute as to whether a court of tribunal has jurisdiction, the matter shall be settled by decision of the court on tribunal. Accordingly, the tribunal convened a hearing on jurisdiction and admissibility in July 2015 and rendered an award on jurisdiction and admissibility of 29 October 2015. Deciding some issue of jurisdiction and deferring others for further consideration, the tribunal then convened a hearing of the merits from 24 to 30 November 2015. The award of today's date addressed the issue of jurisdiction not decided in the award on jurisdiction and admissibility and the merits of the Philippine claim, over which the tribunal has jurisdiction. The award is final and binding, as set out in Article 296 of the Convention and Article 11 of the Annex 7. Historic right and the 9th line. The tribunal found that it has jurisdiction to consider the parties dispute concerning historic right and the source of maritime entitlement in the South China Sea. On the merits, the tribunal concluded that the convention comprehensively allocates their right to maritime areas, and the protection for pre-existing right to resource were considered but not adopted in the convention. Accordingly, the tribunal concluded to the extent China had its historic right to resource in the waters of the South China Sea, such rights were extinguished to the extent they were incompatible with the exclusive economic zones provided for the convention. The tribunal also noted that although Chinese navigators and fishermen, as well as those of other states, had historically made use of the island in the South China Sea, there was no evidence that China has historically exercised exclusive control over the waters of their resources. The tribunal concluded there was no legal basis for China to claim historic right to resource within the sea areas falling within the 9th line. Stages of features. The tribunal next considered entitlement to maritime areas and the stages of features. The tribunal first undertook an evaluation of whether certain rivers claimed by China are above water at high tide. Features that are above water at high tide generate an entitlement to at least a 12 nautical mile territorial sea, whereas features that are submerged at high tide do not. The tribunal noted that the reefs have been heavily modified by land reclamation and construction. Recall that the conventions classify features on their natural condition and relied on historical materials in evaluating the feature. The tribunal then considered whether any of the features claimed by China could generate maritime zones beyond 12 nautical miles. Under the convention, islands generate an exclusive economic zone of 200 nautical miles and a continental shelf, but rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. The tribunal concluded that this provision depends upon the objective capacity of a feature in its natural condition to sustain either a stable community of people or economic activity that is not dependent on outside resources or purely extractive in nature. The tribunal noted that the current presence of official personnel on many of the features is dependent on outside support and not reflective on the capacity of the features. The tribunal found historical evidence to be more relevant and noted that the Spratleys Islands were historically used by small groups of fishermen and that several Japanese fishing and guano mining enterprises were attempted. The tribunal concluded that such transit use does not constitute inhabitation by a stable community and that all the historical economic activity had been extractive. Accordingly, the tribunal concluded that one of the Spratly Islands is capable of generating extended maritime zones. The tribunal also held that the Spratly Island cannot generate maritime zones collectively as a unit. Having found that none of the features claimed by China was capable of generating an exclusive economic zone, the tribunal found that it could, without delimiting a boundary, declare that certain sea areas are within the exclusive economic zone of the Philippines, because those areas are not overlapped by any possible entitlement of China. So the time is up and the article will be continued to read on the next video. So bye bye and don't forget to like, comment and subscribe. Bye!